a lot of people misunderstand what the shot clock was meant to do. The shot clock doesn't force a local jurisdiction to come out and rule. What it does is it provides a clear path to the courts for tower owners and carriers if the local jurisdiction doesn't act within a given period of time. So, and the period of time varies on whether it's a co-location or a new build. It's 90 days for a co-location and 150 days for a new build. Longer than those time periods are considered not to be, quote, a reasonable time period, end quote, under Section 332C of the Act, and it's presumed to be a failure to act. Now, it's only a presumption. Once the carrier or tower owner gets to court, the zoning board can show that it did act reasonably. Local and state agencies, as you would imagine, have not been pleased with the shot clock. They view it as a direct affront to their jurisdiction and their powers. And so at the FCC, there have been petitions for petitions for review that were filed, which the Commission denied. And right now in the Fifth Circuit, Arlington, Texas, and a host of interveners, including the City of Los Angeles, San Diego County, and LA County, have appealed the order. There's one policy that's on the horizon that you really need to think about and get a little knowledgeable about if you don't already know about it. It's the migratory bird rulemaking proceedings. The FCC's rules do not explicitly take into account migratory birds and the effect that the towers will have on migratory birds. A lot of avian conservation groups, what they did was they said that the FCC's ASR registration program violated the Migratory Bird Act and other acts because it didn't have a public notice period. That before you filed for an ASR, you should have to go in public notice for 30 days so that people could oppose it. The court agreed with that, remanded it back to the FCC, sent it back to the FCC, and the court said a couple of things. They said, first of all, we want you to expeditiously create an ASR process which is going to have a public notice process built into it. And second, we want you to conduct either an environmental assessment, a programmatic environmental assessment, or a programmatic EIS to see what the effect of future tower builds will be on migratory birds.
The significant gap test made a lot of sense when wireless first started trying to build out and provide basic voice coverage. We are so far beyond that now that it is just ludicrous that that's even a relevant issue. The problem is that the judiciary is not and never has been the place to try to make technical policies like that. The regulatory agencies have refused to take their responsibilities seriously, both at the federal and the state level. What we have now is because neither the FCC nor the California Public Utilities Commission will step up and do what they really are the only players that have the expertise and the authority to provide uniform and appropriate standards. We instead have judges all over the country coming down with decisions that are just all over the map. And one of the things that the FCC could really, really help with would be to address, at least on the prohibition test, to provide some guidance to the judges so that they realize that it is no longer just a question of is there, quote, coverage, whatever that means. I mean, we're talking about voice coverage, data coverage, 3G coverage, 4G coverage. I mean, there are questions of capacity that aren't even really coverage issues. And the judges don't know any of this stuff.
What I'm most unhappy about at the federal level is something that doesn't really even exist in the regulations, and that is, some sort of overview that would regulate all technologies in a similar manner. we really have legacy regulations that have grown up when these used to be perhaps more disparate industries, and by that I mean wireless versus wireline and cable. And the truth is that all of these service providers are now providing essentially the same services. They are generally digital services, and to have these completely disparate regulatory treatments doesn't make any sense.
Uniformity, it seems, is a theme that we're all looking for, and the FCC has the opportunity to establish some uniform rules, and they've tried to do so. We saw last year with the shot clock, and whether that was a success or not, we can talk about that further. But I think there is a need for uniformity. And the FCC should step in and be clear on uniform rules.
Yeah.
I think increasingly, especially in the San Francisco Bay Area, where you have an educated public, very educated public who likes to get involved with siting. I think you're seeing increasingly a lot of questions about the federal preemption, and people specifically asking why it's there. They want to know all about it. They want to know if it can be challenged. And I think that's
the RF preemption.
Exactly,
Okay.
Specifically for as to the health concerns.
I think the industry, by trying to rely on that federal preemption and saying, we don't have to talk about it, so we're not gonna, has made a really big mistake. And I think that one of the best things the industry could do would be to start really focusing on convincing those people who are scared, trying to convince them that they don't need to be worried about that.
And so one thing I would encourage the industry to think about is, how do we socialize that? How do we get the regulators to recognize that 30% of households now don't even have a wired line phone anymore? 70% of the 911 calls come across a wireless connection, and that suggests to me that if we were regulating on terms of the importance on a societal basis, that perhaps wireless should be viewed in a different way than historically it was 20 years ago.